Okay, good afternoon. My name is Tony Emerson. I'm a District 4 councilman, and the other member present here of our committee. So,
Richard Harmon, District 9.
thank you, Mr. Harmon. Just like to call this meeting to order. This is the Policy and Finance Committee meeting. And our first item of business is to approve the minutes from our August 10th meeting. Do I have a motion?
Motion to approve the August 10th minutes.
Okay, I will second that motion. All in favor, say aye.
Aye.
Aye. Opposed? Okay. That passes unanimously, 2-0. Now we move on to follow up the discussion we had on the August 10th meeting of the Topeka Municipal Code, Title 2 and 13. So we did get a memorandum from City Attorney Lisa Robertson clarifying some of the issues. So I don't know, Mr. Harmon, if you had a chance to look over that.
I have not.
Okay. Would you like just a few minutes to do
Yes,
that?
right.
Okay.
Please.
Mrs. Robertson, would you mind, do you want to maybe quickly go through these for us? I mean, we just, I guess for purposes of maybe anyone viewing this, what these changes
Absolutely.
are?
Absolutely. So as you know, we talked about a lot of the proposed revisions last meeting. I think it was on the 10th. So what I did was take some of the information that you all required additional clarification on or had additional questions on and kind of boiled them down into this memo dated August 23rd. And I can go through each of those if, kind of like we did last time, if that's
Sure,
okay.
absolutely, if you wouldn't mind doing that.
All right. The first section there was a question about is section 2.25050, and you can find that actually at the top of page 5. It's in lines 119 to 121. There was a question about whether or not part-time, seasonal, and temporary employees were covered by the requirement that personal protective equipment be provided. I spoke a little bit with the HR director about this, and we looked through provisions of the Personnel Code. There is an ARR on this that they have been working on, but she directed me to not only the definition of employee, which is in Article 1, I think it's subsection M, but also to the definition of positions, which is in Article 1, subsection X. And positions definitely covers seasonal, temporary, part-time workers. So we feel comfortable that personal protective equipment would need to be provided to those folks
Okay.
and that they're adequately covered.
Okay, great.
The next one would be section 2.25080. That would be on page 6, lines 138 through 170. This deals with the reimbursement for conferences, seminars, conventions, and short courses. And when we were discussing this one, we had initially suggested that the whole section be repealed because there's one subsection on employee travel and then another subsection on governing body travel. And Councilmember Harmon rightfully pointed out that the resolution that corresponds with the travel actually deals with how that money is allocated between the governing body members. So what we're suggesting at this point is to continue with repeal of subsection A, which deals with employees because employees are covered by a separate city policy, the P, I think 124, which is called the travel policy, but that we retain subsection B. And that would continue over onto page 7.
Page 7 there, line 164.
Starting in line 164, we think that you should retain that one because, as was noted last meeting, the resolution does not address, how travel is to be handled. So we're kind of leaving it a little bit broad in here, saying that governing body members can adopt a resolution that provides parameters within which travel is to be complied with.
Okay,
Does that sound okay? All right.
sounds great to me, thank you.
Okay. The next one we talked about was approval of employment and severance agreements. That's on page 8, lines 171 through 173. We had initially talked about potentially repealing that section. But in looking back at the personnel code, we were looking for the recruitment and retention policy. That's actually covered in an ARR. I think that's the one that you all are currently working on. So what we propose at this point is to leave this 2.25090 in place as is until the administrative rule and regulation is completed by HR.
And that would be like from 171 to 176?
171 to 173, because
okay.
what we put in here now, we didn't put repeal and then cross everything out. We just renumbered it.
Okay,
So that's all that's happening with 090 is that we're suggesting renumbering it.
okay, thank you.
Good. All right. Next one is section 2.25100. That's on page 8 of the ordinance. That is entitled Accounting Upon Separation from Employment. Councilmember Harmon had asked whether or not another word other than audit could be considered. We agree with that, so we've replaced audit with inspection in line 180, if that sounds acceptable.
So an inventory inspection will be conducted in accordance with policies adopted, okay?
To make sure they turn in everything that they're supposed to turn in.
Any thoughts on that, Mr. Harmon? No. Good with that language? Okay. Okay, we're fine with that?
Do you want me to suggest that? How do you all feel about the word review instead of inspection?
Do we have,
What about possibly dropping the word, just saying an inventory
Yeah.
will be conducted?
Yeah, that's what,
Is that
Yeah.
what you just said?
yeah.
Okay.
Great minds.
Okay,
Okay, we will do that.
so we'll strike the word inspection there. It'll just be an inventory will be conducted in accordance with policy.
Right. So when you see it, when we present it to the body, it will say an inventory audit will be conducted, and we'll cross through audit, because we haven't made this change to inspection yet.
Okay, okay,
So we'll just cross through audit altogether, and it will say an inventory will be conducted.
great.
Okay. The next one is 2.25110. That is on page 10 of the ordinance. In lines 227 and 228, Councilmember Harmon had suggested that we add the words, "The city clerk shall be responsible for the overall operation of the city clerk's office," because that same language was contained in some of the other references to the
sure.
other departments, and that made sense, so
Yeah.
we've added that.
Great suggestion.
So those are all of the changes that we talked about at the August 10th meeting. At the bottom of the memo, you'll see, oh gosh, no, I'm wrong.
That's legal
Skipped a
department.
page ahead. Sorry, we're still on our proposed revisions, I take that back. So the next one's 2.25120, that would be on page 11. And that had to do with a question raised by Councilmember Jensen about the question that gets asked all the time about who does the city attorney represent. We had a discussion about the rules of ethics would require the city attorney to represent the city and not just the body and not just the manager. But the committee had asked for some information on what other cities do and how they handle it. And this is part of the reason I asked Catherine to be here. There's attached to the memo as attachment A is an actual chart that outlines what the cities of Lawrence, Manhattan, Olathe, Salina, and Wichita, how they handle the same situation. And as you can see, it's really not too much out of line with the language that we have in our municipal code. And I go into it a little bit more in depth in the memo, but Lawrence and Olathe don't even have a provision that creates a
That's
a
very
legal
interesting.
department. And then Manhattan, Salina provide that the city attorney shall advise the body, the manager, and the officers of the city upon all legal questions, and then it continues. And Wichita states that the city attorney is the chief legal advisor to the council and the manager and shall be parliamentarian.
Okay.
So I'm not sure kind of what you all might like to see when we send this up to the body, but Catherine, I think, did we have one of our interns research that?
Yes.
That's what I was thinking, yeah.
I pulled this information.
They pulled all the information. So,
I'm not certain. I mean, it sounds like there's just some ambiguity always left in this case, and it probably, it's never going to be an issue until there's some big issue. Mr. Harmon, you've been around a lot longer than I have, any input?
No, I think the changes that were initially suggested are appropriate, and I don't believe any further revisions or modifications are indicated in light of the recent reform.
I would agree.
okay. All right, now on to page 3 of the memo. The next sections would be 2.25130 and 2.25140, and this is on page 12 of the proposed ordinance in lines 269 to 273. This had to do with the question on whether or not the city treasurer that creation of that position should be deleted entirely from the code, or whether or not it should be bumped up into the administrative and financial services piece where the director appoints the treasurer. And I think after we talked on August 10th, we kind of made the decision that, let's just take it out.
Right.
But there is a charter provision, and it's attached to your memo as attachment B. It's section A2-41, and its designation as officers. And when you read through that, the city treasurer is designated as an officer in that, and that's a charter ordinance. So what we were thinking is that we ought to perhaps just leave it as a new subsection B under administrative and financial services and just state that the director of administrative and financial services needs to appoint the treasurer. And then at such time when the charter gets revised to reflect a more updated version of titles of officers, that then we can change it. But we weren't quite comfortable changing it or just deleting it entirely
Like something
with that
specifically named in
provision.
the
So, not sure what your thoughts are on that, but that's kind of
Can
what our
the
recommendation is.
Can the director of admin and financial, can they be the city treasurer? Can they appoint themselves? Or does it have to be a,
Well, I don't, if you look at that charter provision, yeah, I think you could change city treasurer to say the director of financial and administrative services.
If I could,
Yes.
the chief accounting officer is actually the person. Oh, I'm sorry. The chief accounting officer is actually the person that has been appointed as the treasurer through their position description duties. And that position reports to the director of finance and administrative services. So
okay.
I don't know that I would actually name the director because the director has appointed that to that position.
Could the director, when you change the position descriptions, if the charter gets changed, could that, part of what those responsibilities are under the Director of Administrative and Financial Services be to serve in that capacity, or do they need to be separate?
I think that the chief accounting officer is appointed because they are more associated with the day-to-day banking transactions,
Or the
et cetera, and the revenue for the city. And so that's why that appointment is the way that it is. I think it's possible, but I think that that's why it's delegated as such right now.
So if we change the charter, then we would take out perhaps city treasurer and replace with
Or even
chief
say-
accounting officer
Yes, or the director of finance and administrative services, and then.
or designee.
Or designee or something like that. Ultimately, the director is responsible. I just felt it important for you to know where that day-to-day responsibility is actually assigned.
Right, and I guess my only thing is, in reading this charter, it seems like the city treasurer is almost like a department head, because everybody else here in this list is the city attorney, the city clerk. So it almost seems like it's assumed that would be a department head, like they would be the head of finance. And I think what you're saying, Jackie, if I hear you correctly, is the position description assigns the duties of the treasurer to the chief accountant.
Yes.
But I almost think, though, this is, the city treasurer as named here is like a department head, it seems like, from our charter ordinance. Is my only thought. I don't know operationally if this matters. I mean, probably doesn't.
I don't know that it matters. I'm sorry.
No. Go ahead.
I don't know that it matters that much operationally, but it should be reflective of what's in the charter. They should match, so however we want to do that, that makes sense. We could do it at some point.
I agree, Your Honor. I agree that they should be consistent. If we amended our charter to remove that, the city treasurer, would that have to go to a vote of the people?
Is that every charter amendment has to? Okay.
I'm saying yes.
Okay.
But,
I'm not sure.
yes.
Okay, you think it would?
It seems like an immaterial change.
Yeah, it seems. Oh, well.
We'll check into it.
Yeah,
They-
I mean, it's,
If they don't, I'm sorry, if
Go
they
ahead.
don't directly have to go to a vote, there is a process for a certain percentage of electors to force a vote, is there not?
Oh, by petition.
Yeah.
yeah, you know.
Yes,
Yeah,
please.
it seems like we went through this early in my term about certain changes to the charter do need to go directly to the voters, and some we can change by governing body action only, subject to.
Petition.
So, and perhaps it's just an academic issue, but I certainly agree with the city attorney that they, as long as the city treasurer is named in the charter ordinance, then we need to be.
Need to have one.
Reflective of that. So. Thank you.
The next provision is 2.25150, and that's on page 13, Judicial Department created. We're not suggesting any proposed revisions to this one, but I did want to make a note that Councilmember Jensen had asked the question about whether or not the governing body should ratify the selection. And this comes back to the charter amendment and whether or not it's worth going through all of that to accomplish this. And I think he felt at that point in time, on August 10th, that it wasn't, but I just want to make mention of it.
Sure, thank you. I'd agree.
Then 2.25170 is Public Works Department. That's on page 14, lines 314 to 320. This comes back to the city engineer position and designation of that individual. This is along the same lines of the city treasurer, but city engineer is not mentioned as an officer in the charter. It's just that Braxton had raised an issue last time that this position is mentioned in a lot of provisions of the code. And so attachment C to the memo shows all of the sections in which the city engineer is mentioned. It can come out, we can delete reference to it, or we can leave it in as a subsection B under the Public Works Department where the director appoints. I think that's basically up up to you all, just depending on what you're comfortable with.
What were we proposing last time?
I think with both the treasurer and the engineer, you all had said just to delete references to those positions in their entirety. And staff's recommending that we bump the treasurer back in, but on the city engineer, that's not referenced in the charter, so it's really a policy decision of whether or not you want to delete it or retain reference.
And just my opinion on this is, the city engineer is listed also in your contracts. Every contract I ever see as a contractor, city engineers referenced time and time again. So I think in addition to all these things, you might also have to revisit contractual language. And I don't know if there's a compelling reason to eliminate that. I don't know what would be gaining by eliminating that.
I'm absolutely fine with retaining it if that's what you all
Your Honor.
are
Yes,
comfortable with.
please.
The fact that in attachment C, there are many references in existing code to city engineer. So for us to delete that, I think would cause a lot more problems than it solves. Otherwise, we'd have to go back to each one of these listed in attachment C and amend. I don't think we need to do that.
I would agree.
Okay, so we'll just leave in subsection B under the Public Works Director and have him appoint that person.
Yes.
Okay. All right, so now we are down to the bottom of the memo. And this, on page 1, if you go back to page 1 of the ordinance, we did not talk about this particular proposed revision. It would be to 2.14010, and it deals with the city manager's review and evaluation. We didn't talk about it on August 10th, but given the process that we've gone through the city manager selection, we thought it probably would be a good time to bring it up and just combine it with this Title II and all the revisions that pertain to Title II. Currently, there are specific dates contained in the municipal code as to when the person needs to be evaluated, when goals and objectives need to be presented. And instead of having specific dates, we thought it would make more sense to just give timeframes so that, if something happened where you didn't get done what you needed to get done on that specific date or by that specific date, you had a more general timeframe, whether it's 60 days or 30 days to get done what you needed to get done with respect to the review. And what I did was kind of incorporate some of the language that we incorporated into the contract as far as that the evaluation needs to be written, that goals and objectives need to be provided after the evaluation's completed, just to firm it up a little bit. So I wasn't sure what you all thought about that. We can certainly take this back out and not deal with it. I just thought it was a decent opportunity to kind of address this issue at the same time.
So Lisa, as I read paragraph B here, it says the governing body shall set an annual 60-day period with which to conduct a formal written review and evaluation of the city manager's performance. And is it almost like we're just saying, hey, for this 60 days, we're going to watch you and evaluate you? To me, that's almost what that says. Like the rest of the year, we're not doing that. Is that the intent?
No, I think this really pertains to the annual review, but you have a 60-day period within which to do what you need to do. So it's not that you're looking at their performance in a 60-day period. It's that it's an annual review, and you just have to make sure it gets accomplished within the 60 days. Am I saying that right, Jackie?
Sure, please.
If I could, so for example, the governing body could say that they're going to review the performance of the city manager on an annual basis between November 1st and December 31st or something. So it gives you a window of time versus how it is now, where it says by March 31st of each year. So it would be a 60-day window on an annual basis by which you would review the performance of the last year.
Can I offer a point just for consideration? Instead of I absolutely agree with what legal and HR have recommended in terms of eliminating that date. But instead of handcuffing you by a 60-day, why not just say simply the governing body shall annually perform a review of the city manager's performance? And then that gives you some flexibility in terms of when they start,
Right.
you know.
The only consideration that I would say there would be that in the contract that you just entered into with the new city manager, the performance and pay are to be matched to those of the management and executive employees, and that will happen the first pay period of each year. And so the management and executive employees are being reviewed between November and December annually based on the pay for performance that has been implemented.
Okay.
So that's the rationale for the example that I gave, just because of how that performance and salary are tied in that contract
So we really need it done
by the end of the year.
by the end of the year, which would still, though, that would still qualify, wouldn't it, in that, in Braxton's example? It was done by the end of the year, but you actually need some lead time, correct? I mean,
We do need some lead time, at least 2 weeks lead time is ideal. So by the mid of December is ideal, but I just didn't know if you would want a date again in here.
right, right. Of course, if we set a time period, that's an additional task we have to do every year to make sure, somebody has to track and make sure that we set the time period and then that we conform to those parameters. I would kind of like to just set a date, a late date. It has to be done by X. And then our calendar, sometimes we're busy if there's zoning cases or, maybe we'll have a TIF thing this year that will be taking up a lot of time in November. I don't know. But I kind of like having a date, but a late date, that.
Couldn't we just say that by December 31 of each year?
We could make that work.
Okay. Yeah, how about that? Is any objections from anyone? And in this, but I guess going back specifically to this year, Mr. Trout's going to be starting at the end of
October 30.
Yes, October, thank you. And does that in any way conflict with anything we've told him as far as a?
No, I think that your agreement said that there'd be a 6-month review and then annually thereafter, so there's no conflict there. Because this would be saying that there'd be one done annually. If the date, I think you would just have to interpret that doesn't apply since the employment has just commenced.
Okay. Does that sound reasonable too? Okay.
So it'd say the governing body shall conduct a formal written review and evaluation of the city manager's performance by no later than December 31st of each year.
Not to beat a dead horse, I would just throw out for consideration, if you simply leave it as the governing body shall annually do that evaluation, that's what's going to be in the ordinance. There are two things that are driving this deadline of December 31st. One is the employment contract. The second is that under the compensation plan for executive, that those evaluations have to be done before, by whatever date, November 15th. If one of those two things should change, then that could potentially throw off what you have in the code. That's why I would say for the code, why not just leave it as annually perform the evaluation? And then if there are overarching things such as compensation policies, employment contracts, those necessarily need to inform the decision-making of the governing body. And I just put that out there because, as we all know, things change. New
Right.
city manager could come on board and we could have some other code changes or contract changes. And instead of having to go back and chase this to remove a date,
Yeah, okay.
just something to consider.
And I agree wholeheartedly, because the reason why it doesn't fit anymore is because the March 31st date was designed to coincide with elections, and then the
Right.
state law changed. So we have things like that that can happen that would necessitate a code change as well. So I think that makes a lot of sense.
Well, I retract my, my suggestion about a date then, and I'm fine with saying annual and that. And I guess that would too, might even capture with Mr. Trout. Maybe we want to do his review in, October of next year.
I think it would cover what you've got in the contract as well.
Yeah, great, okay.
So then it would read, the governing body will conduct a formal written review and evaluation of the city manager's performance on an annual basis.
Yes.
Good?
Sounds good to me.
All right. The rest of this is pretty standard, and a lot of this is contained in his contract, but it states that the governing body shall provide the manager with a summary of its input and comments related to period of time covered by the review, and then provide the manager with an opportunity to respond, either in writing or verbally. Good with that?
Yeah,
Okay. So I'll just add this in then. I think it makes sense, so I'm glad the timing kind of worked okay with this, so. Okay, so that's all I had, unless you all have anything else or any additional questions, at least for Title II.
Mr. Harmon?
Good?
I'm good. And do you
Okay.
think at this point, do you feel comfortable that we would go ahead and send this back to the full council?
Would you like me to put it on, well, maybe we ought to wait till the Title 13, but I could put it on try to get it posted for September 5th meeting, if that's what you like.
I don't have an issue with that, but is there any need to get it on that meeting?
Well, the utilities are going to be there anyway because we've got the utility lien ordinance. And so my suggestion would be, as long as we're going to be there and talking about utilities on the utility lien, we could take up the
Great.
13 and 2 items as well.
Okay, that's fine with me. I don't have an objection to that.
Okay.
And I know you kind of pre-warned us, so.
Yeah, well, I wanted to warn the council because it was not posted, and I
Sure.
didn't want them to think, where did this show up at? So
No, I
wanted to make
appreciate
sure
that.
it was.
We need a motion to approve.
Yeah, there needs to be a motion to approve, and then they need to decide whether or not they're going to make a recommendation.
So,
Would you like to make a motion to approve
Yes.
these revisions to Title II?
so yes, I would make that motion that we make the changes that we discussed today and then send it back to the full council with our recommendation.
Second.
Any discussion? All in favor, say aye.
Aye.
Aye. I'd say that carries unanimously.
And that was a recommendation do pass. You just said with your recommendation.
Yes, to pass.
Okay.
Yes,
Just wanted.
No, I
for- for
appreciate
the-
that.
For the record.
absolutely, I appreciate that.
Did Mr. Dole have one of the vote on
Not on that issue.
that? Okay.
It's on the utility. Now, I do not have, was there also something in the utility that we needed to discuss?
I did not send anything on utilities. I didn't know if there was anything additional that.
No, there were no questions or comments or requested revisions to the utilities ordinance
Okay.
that were made in the last committee meeting. But I'm here and happy to answer any questions that you have.
I have no further questions.
Okay, nor did I. We do have one gentleman who'd like to speak about utilities. Mr. Delap, if you'd come up here, please.
Thank you.
Thank you.
Thank you.
Thanks, Pat. I said, thank you, Pat.
What I'd like to talk to you about is an issue I tried to resolve internally. About a year ago, it ended. You know, we're picking on some things which are kind of small, so I thought this would be the effective. Small things we're also changing in the code that a licensed contractor can attach water lines to the city property 1 inch, 1.5, 2 inches, as long as they're working under a city contract right now. What I approached about a year ago was the fact that I'm a landlord. I've seen people forget to turn the water off on the water line. They're gone. I've had another one last year. A person went into a nursing home because of HEPA laws. I wasn't able to find her, things like this, but she was gone, not coming back. What happens, I called the city to turn off the water. They're no longer there. They're not using water service, and they had refused. They said, we cannot turn off the water. And I thought, well, come on, I can, they're not going to be using it. Services are available, but they're not using it. You're just running up a bill unnecessarily when they're not going to use anything for it. Says, how about an affidavit from me that, to a fact that they're no longer live there, and then you can shut it off. And they ran it through, purportedly went up to the city attorney's office, and I assumed since I was dealing with middle management, Braxton was also aware of it, and so was Mr. Sample, because that's the way the change should work. You go up there during time policy change. What it came back is they would not do it. I could put it in my own name, but they wouldn't turn the water off. Well, I didn't need it in my name. The house is ready to go, things like this, no reason to do that. So it remained on. The bill runs up to about $300, then they shut it off, then they turn the person in for collections. And they'll eventually get that money, either tax offset or fine and things like this. Exception is if they're deceased. It was third hand that it came back. I didn't receive a direct email from the city attorney's office, but they said there's constitutional issues with turning off water when you didn't order it on. And, well, I think the affidavit would take care of that. I'm looking at this from an issue of fair play. Is that fair to people? Yes, we're bringing revenue into the city, but should we be doing that? In a sense, I would benefit a little bit myself if I could turn the water off, if it's winter time. Here I've got winter coming on. I'm going to mothball the house. I've got pressurized water in the house. I don't want to heat it and pay that water bill. What's going to happen to my pipe? It's going to break. I want that water off. So I'd like this committee to consider that, putting in it some exception that with a affidavit, a landlord can have the water shut off. The affidavit will stipulate the tenant has left. Now, we do run into issues of why we need that affidavit. Is you cannot in Kansas do something that's called a constructive eviction. Constructive evictions, we're not getting along, I want you to leave, I'm taking that door off the house, or I'm reducing your utilities. You can't do that in the state. But with that affidavit, that's basically, it's a slam dunk when a person would try to do that as far as prosecuting them for doing something improperly. I think this is something you should really consider, and I think many people would benefit from that. And I'll stand for questions.
Mr. Harmon, any questions?
Well, I would like to, at some point, have legals and utilities thoughts. And then the second issue, does that have anything pertaining to the restructuring of the utilities department that's on the agenda?
No. Pat, I don't know if you realize this, I only came back about 4 months ago to the city, so this is the absolute first time that I've heard that. I was gone for about 5 years.
You know, now that you mentioned it, I do remember reading something, you're back.
Yeah, so.
I apologize. Yeah.
So from my perspective, Pat, I would like the opportunity to take a hard look at this particular issue and see if this is something that can be resolved through a policy administratively as opposed to through a city code section. I'm absolutely aware of the provision under the Residential Landlord Tenant Act that prohibits you from interfering with a tenant by shutting off their services, but the factual scenario that you've laid out, that would not apply. But I'd also like an opportunity to let legal look at this and for me to visit with them and to see if there's some way that we can handle this administratively.
Okay.
As opposed to through a code. I mean, it's a good, I appreciate your bringing this issue up to us, and And there are a lot of issues there, but I'm wondering if there isn't a more creative solution that can be come
I
up with
thought the same
administrative.
thing when I was reading this, but then I heard you on the 10th bring up allowing contractors to hook up the water lines for 1 inch, 1.5, and 2 inch. As opposed to right now, the code says city employees must do that.
Well, that, actually, in the committee meeting a couple of weeks ago, we addressed that actually, we have amended that code section to clearly reflect what the policy is, and it's taps on 1 inch, 1.5 inches, or 2, I believe, can be done by a city contractor under the supervision of a city inspector. And so that, when this goes back in front of the council, that additional amendment will be reflected in that code section.
Okay, that's why I thought this might be a place for it.
So,
Okay.
and after this is over, I'll just visit with you for a second, give you my card, so you have my contact information, so I can get a better sense. I've not had a chance to read this, of what your conversation was and why you wouldn't want to have like a revert to owner that I know we have in a lot of apartment complexes.
We do. No, that's not something I'm seeking. I'm just seeking to have the water shut off.
Okay.
More of a thing. Yeah, it's not self-serving. It's like, why are we billing these people when we really shouldn't? They're gone. Now, some people would take advantage of not doing that and clean up the house with the water in the tenant's name, things like this. Arguably, they burn them, things like this. But then there are many other cases. They just forget to turn it on. You rarely get a forwarding address from them to tell them that. So you have to send a last known address, which is your unit, and you have to hope they put in a change of address with the Postal Service. In the case I had recently, I did have somebody go to a nursing home. I was working with a social worker. She picked her up from the floor twice, and finally she was on the floor for 48 hours. Wow. And we put there, and same thing. We couldn't shut off the water because the HEPA laws, which is the healthcare laws of privacy, I wasn't even allowed to know where hospital she was in or where they changed, things like this, which was the problem there. She can't. So they had to run up a $300 bill, and they shut her off then finally.
Sure. Yeah, Mr.
thank
Lapp,
you.
if that works with you to get together with
Absolutely.
Braxton, great. In that case, then, I don't see there's any changes proposed or needed in the Title 13, so I would move that the committee recommends back to the council approval of Title 13 utilities.
With recommended to pass.
Yes.
Okay, I would second that.
All in favor?
Aye.
Aye. Okay, motion carries 2-0. Are there any other items anyone needs to bring up before the committee? Well, seeing no further business before us, I hereby consider this meeting adjourned.
Thank you.